Fifth forbearance or Step 6, Judicial Foreclosure. Let me break down the foreclosure process into easy-to-understand steps. These steps should not be used as legal advice. Judicial foreclosure begins when the lender files a lawsuit. The lender will sue the borrower and any person who has a claim to the ownership or a possession interest. The lender, as plaintiff, has a summons and a complaint served on the borrower. The summons commands the borrower to come to court and answer the lender's complaint. The complaint is the lawsuit proper, which describes the lender's legal and factual basis for foreclosure. A notice of lis pendens must be filed. The lis pendens is a notice that a lawsuit is pending, the outcome of which affects title. Often, the borrower fails to answer. In that event, the court will appoint a referee to compute a figure for the foreclosure. The court may then sign a judgment of foreclosure on sale. If the borrower appears in defense against the lawsuit, then the court will determine the merit of the defense. The referee will need an oral hearing. If the lender wins, then a judgment of foreclosure on sale will be awarded. Typically, the foreclosure sale is advertised 4 to 6 weeks. The sale is made by public auction to the highest bidder. The lender may bid as well. The lender must distribute the proceeds according to the terms of the judgment signed by the judge. Surplus money will normally be held by a referee. Let's examine the judicial foreclosure process in more detail. When a property goes into foreclosure, as is the case with Jack when he falls behind on the payments to the bank, state law dictates the actual foreclosure process. You need to become more familiar with the foreclosure process in your area. In most states, properties are held by deed of trust. In these trust states, the foreclosure process is much faster than in non-trust states such as New York. Foreclosures are auctioned off at the county level via trustee sales arranged by the lender without the involvement of the state courts. These are non-judicial foreclosures, meaning that the court is not involved. Therefore, the time between a lis pendens of mortgage default and the foreclosure auction can be as quick as several months. In New York, loans for real property are secured through mortgages rather than through deeds of trust. New York, unlike trust states, is what is called a judicial foreclosure state. Only 10 states, Connecticut, Florida, Indiana, Louisiana, Maine, New Jersey, New York, North Dakota, Ohio, Pennsylvania, and South Carolina are judicial foreclosure states. Simply put, most foreclosure proceedings in New York or other non-trust states must go through the courts before a property can be sold at public auction. On average, it takes 12 to 18 months after a lis pendens notice of mortgage default has been filed for a foreclosure proceeding to move through the court system and the property to end up on the auction block. What is the reason it takes 12 to 18 months for a foreclosure proceeding to move through the courts? In a nutshell, all parties named in the action, including other mortgage holders, creditors, tenants, or the owner, must be served with papers. Why is it important to know the difference between judicial and non-judicial foreclosure? Because you need to know the laws of your state when educating yourself about the foreclosure process and investment strategies. Many books, foreclosure seminars, and infomercials provide information that focus exclusively on deed trust states and trustee sales.